Don't give the farm away when you're transferring real estate. In this episode, we're going to talk about the things you need to consider as you look to transferring real estate. For many families, their largest asset is the home they live in. Other families have not only their residence, but also some other real estate. And very often, that is a big topic that I talk with my clients about. How to make those transfers the most tax efficiently. What's the best way to do it? Should we do it while we're still alive? Our kids would enjoy the property now. I want to transfer it now. Are there tax reasons that you might want to hold off? Yeah, there are. They may not be absolutely determinative of what you want to do. You may still want to do it anyway. But one of the things we're going to go through today is the tax situation surrounding some real estate that you might want to keep in mind as you make these determinations, when to give that piece of property. Is it always necessary that you have to wait till you die to give it? No. What are the different factors you'll consider? So we'll talk about giving during life. We'll talk about giving at death. We're also going to talk about the taxation considerations. We'll talk about the different methodologies that you can use to transfer property at death. Wills, trusts, transfer on death deeds. What's the best fit for you? Don't know, really. It's going to be a matrix of considerations that you may need some advice from professionals with, but by the end of today's episode, you'll at least have an idea of the right questions to ask. So glad you're joining me. I'm Jim Miskell. This is Let's Talk Estate Planning, the podcast dedicated to my dream of a world where everybody's got their estate planning in order so that when grief, crisis, and transitions occur, families aren't running around town trying to figure out how to do administrative stuff. They've got a roadmap and can spend time where they really should be spending time, and that's together, spending time with one another. The podcast is not legal advice. I'm an attorney, 30 years plus, 32 years practicing in the state of Georgia, and I'm licensed only in Georgia. Purpose of the podcast is not legal advice. Legal advice happens when you're sitting in front of an attorney who you have paid to represent you, and you have a relationship with that attorney and can get the best advice based on all the facts and circumstances of your situation, not just cherry picking a couple details and saying, well, if this, then what? So it's really important to have full consultations with attorneys. But back to my point, this is not a consultation with an attorney. So the purpose of this podcast is educational. Hopefully some entertainment. We'll try and keep it light as we go to give folks the information that they need to think critically about their estate planning, whether they're just beginning their journey or are thinking about refinements that might be needed as times and circumstances have changed for their families. That's my disclaimer. This is not legal advice. It's a podcast. Now, let's get back to the material.
With the gift of a piece of real estate, then the question is, first, is it going to be a lifetime gift or a gift at death? Because there are certain tax advantages that we've discussed to giving at death, that step up in cash basis, that may lean for a lot of these transfers to be at death transfers rather than life. But there can be factors that make it important that the transfer happen now. It may be part of a business opportunity that the beneficiary is developing that you want to contribute to. There's any number of reasons why the transfer now may trump any of the tax implications. One example would be, let's say that there's no gain on the property. Now, we've been in a climate here over the last few years, certainly in the Atlanta area in particular, where any real estate that's been held over the last 10 or 15 years has almost certainly increased significantly in the value. And that property is going to come with a lot of capital gains, and we're going to have a lot of capital gains built into it. But there can be properties that might even have little to no gain or a loss, in which case that step up in cash basis at death is not going to be much of consideration. And if you want to give it during lifetime, it's not going to make any difference from the tax perspective. So if it's got to be a lifetime gift, it's got to be a lifetime gift, and you can just deal with the tax consequences as may be. And maybe the tax consequences are insignificant. So in the case of a property that doesn't have a lot of gains in it, or perhaps even a loss, and with a situation where there's a loss, it might be desirable to make that transfer in any event during life. So if it looks like it's going to be a transfer at death, you can do that through a will, through a trust, or through a transfer on death deed. Those are going to be your primary three ways to transfer real estate at death. Those three are identical when it comes to valuation for step up and cash basis, but there can be significant differences and practically how they work for the beneficiary. With a transfer at death, you've got three primary ways to choose to convey that real estate, that property. One, through a will. I hereby bequeath my real estate to Bob. Second, through a trust. I hereby direct my trustee to give that piece of property to Bob. Or third, a transfer on death deed. A transfer on death deed allows you to specify who's going to get it when you die. Bob says, when I die, Bob gets the land. So if the decision is taken that it should be a transfer at death, there's going to be three primary ways that that can be done. Either through a will, through a living trust, or through a transfer on death deed.
Okay, great. So let's talk about some tax stuff before we talk about making decisions. So two things you want to keep in mind. Each of us, when we sell our residence, have a homestead exemption for capital gains taxes from the federal tax system. And for individuals, it's $250,000. And for couples, it's $500,000. That means if I sell a home that gives me gains of $250,000, I don't have to, or under, I don't have to worry about capital gains exposure on that. Likewise, a couple, a married couple, $500,000 on the sale of a home. Now, there's some requirements that go with that before you can take advantage of it. And there's this residency required, and it's kind of a 5-year rule. You have to have 2 years, well, it's 2, 2, and 5. You have to have 2 years ownership, 2 years of residency within the 5 years before the property is sold. And weirdly enough, they don't have to be concurrent exactly, the ownership and the... So anyway, that is sort of the requirements for that. The other thing to keep in mind is what's known as a step-up in cash basis. So real estate is one of the types of assets, and among the others would be stocks. That's what most people think of. But for real estate and stocks, when you make a lifetime gift of that kind of asset, and we're just going to stick with the house. You give a house to your kid. When they turn around and sell the house, if they turn around and sell it immediately, their capital gains exposure, because it's not their residence, so they might have exposure, they sell the house, will be what they sold it for minus what you paid for it. So if I buy a house for $25,000 in 1995 and I give it to my son and he turns around and sells it for $100,000, it's going to be $100,000 that he sells it for, less the $25,000 that I paid for it in 1995. If, on the other hand, I make the same gift to my son, but instead of being a lifetime gift, it's at my death, whether it's through a will or a living trust, doesn't matter. When he gets that house and he sells it for $100,000, when he goes to look at what his capital gains exposure is, it's the $100,000 that he sold it for, less fair market value the day I died. Probably that same $100,000. There's no capital gains on that. That's called a step-up in cash basis. And, of course, the cash basis, as we've talked about, is what's used to figure out what the gain is on that piece of property. And it's subject to capital gains. And capital gains is something that you need to keep an eye out for real estate, stocks. There are some other assets as well, but those are the two primary. So keeping those couple things in mind at taxes, let's talk about making the decision about how and when to give a gift of real estate.
This is not the first time, it certainly won't be the last time that we discuss using a will to transfer real estate. Of course, anytime you use a will, you're looking at the probate process. So that can cause delay. Hopefully, if everybody's getting along well, all the heirs will sign off on the probate. It'll go fine, no problem. But you're still looking at 30 to 45 days minimum, usually, before you can even move to list a piece of property for sale or for the executor to have the authority to transfer a piece of property. So there's that delay, of course, with probate. In addition, if this property is in a different state than where the decedent lives, if you live in Georgia and you own property in North Carolina, when you die, if you want your kids to have it, if you use a will, your kids are going to do probate first in Georgia and then go do ancillary probate in North Carolina or Tennessee or Florida or wherever that other piece of property is. So there are some strikes against the use of a will to transfer real estate, particularly when there's real estate in other states other than the state of residence where you live when you die. So wills work. They do what they do. but may not be optimal. The will not interfere with any of the tax structures, and it won't disallow any of that, and anything that they're entitled as far as step-up in basis and that sort of thing. No problem. No difference with a will versus anything else. The transfer on death deed, now Florida, Texas have had these for some number of years. Other states have them. A lot of times they're referred to as ladybird deeds. Georgia, we've had it since July of 2024, and the transfer on death deed works like a transfer on death designation would. Essentially, it works the way a transfer on death designation works on a stock account or anything like that. It's a deed that you actually sign and file, record with the Superior Court Clerk's office in the county where the piece of property is, and it says, when I die, here's who gets the property. There are some limitations to this. It does what it does, and I'd say a situation where there's a only child, where things are pretty simple, it can be pretty effective. But it's very limited. The transfer on death deed has some limitations on contingencies. For example, if I were to do a transfer on death deed to my 3 kids, and I'm in the car with one of them and we both get killed, the way the law is in Georgia at this point in time says that child's share, one of my 3 kids, let's say it's my son Matthew, goes with me, Matthew's share wouldn't go to his kids if he has any. His share just disappears, and then there'd be halves of the property conveyed to the other 2 kids. So it's kind of limited in what it can do in contingencies. That's where a will or a trust is stronger than the transfer on death deed, because life happens and things in life very often go differently than we expect them to go. So transfer on death deed, a little limited on contingency. It does what it does, but it doesn't address contingencies very well. And if all your beneficiaries on a transfer on death deed, you're right back in the will and going to probate anyway. The use of a trust to convey property really has a lot of upsides, and you can be pretty creative with it. First of all, it avoids that probate that's required with a will. And so that's in its favor. It's certainly better with contingencies than a transfer on death deed, just like you could in a will. It says if my son isn't there, it can go to his kids, or what happens with it. You can do if then to as many layers as you feel like you need to for a responsible protection. A trust has that in its favor. And the use of a basic living trust, particularly when it's a grantor trust, doesn't interfere with the tax situation. What do I mean by that? I mean that any homestead exemptions that the grantor of the property is entitled to isn't affected by the use of a living trust versus a will or another mechanism. You still get the step up in basis. You're still eligible for all the homestead exemptions you would be during life. Owning a living trust doesn't affect that. So a living trust transfers very effectively at death without having to go through the court process. For all the reasons that we've talked about many times, the strengths of living trust versus wills. The other thing that a trust is really good at is separating benefit from decision making. What do I mean by that? I mean that you can give somebody the right to reside in or use a piece of property without transferring ownership to them. So in a situation where you want a beneficiary to have the benefit of using a piece of property, you want them to have the availability to use it, to build a business, to reside upon a piece of property. I could set up a trust and allow my son to live on or use a piece of property, but still retain the ownership in the trust. That allows the use of the property during my lifetime by my son, but it still preserves the step up in cash basis. I haven't actually transferred the ownership at this point in time. So there are situations where clients may feel like the use of that property, it's really important to make that transfer now, that there's a business opportunity, there's a reason that you want the child to have or beneficiary to have that piece of property now for a good reason. You can give them all the benefits without actually transferring the ownership until death, which preserves some tax advantages if you need them, if there's a capital gain in the piece of property, and if there are tax exemptions that are available to me as an owner that I'd like to keep, even though I'm letting my son use it in the meantime. So the trust can be the best of both worlds. You can make a lifetime gift of benefit and make the transfer of the actual ownership of the property, the rest of the ownership interest at death. So transfer on death deeds only do one thing. They transfer at death, and they're limited as far as contingencies. wills, you can put plenty of contingencies in, but they only make that transfer at death. With a trust, you can have the best of both worlds. You can transfer use of the property, benefit of the property now, but still preserve that step up in cash basis, the other tax advantages, by reserving the actual transfer of the property to be an at death transfer. So there's a lot of different ways to slice it. We've talked about a lot of things in this episode, but what it really comes down to is just making you aware that there are several layers of factors to consider. There's an immediate desire to use the property or transfer it now. You can accommodate that, but you don't want to do that at the sacrifice of significant tax efficiency, meaning you don't want to make it harder on the family, yourself, or the beneficiaries by doing something that seems expedient that might come back to bite you. So you don't want to give away the farm while you're giving away the farm, or put the cart ahead of the horse or the horse in the cart or something. In any event, there's a lot of things to consider when you're transferring property. The best way to proceed is consult with your tax preparers, consult with a licensed and experienced estate planning attorney so that you can take all these factors into account and come up with the situation that best blends those factors to the advantage of your family. You know, not every family is going to come up with the same result on the same set of facts. For some folks, the transfer, the autonomy, the decision-making is going to trump any of the tax considerations. For most families, it's sort of a blend of the two. For some families, it's all the tax consideration. What makes it come out the best for taxes are going to have the priority. So it's a really individual thing, like all of estate planning is. I hope I've given you enough information today to realize that there are a lot of factors here. I maybe haven't answered any questions, definitely. Why? Because I don't know all the factors in your situation. We haven't laid them out, but it's enough to be aware that when you're getting ready to transfer real estate, there's a lot more to be considered than I just want them to have it now. And there are several ways to structure a gift, whether it be a gift during lifetime, a gift through living trust, a gift with a will, or a gift through a transfer on death deed. All of those are available. They don't all have all the strengths that you might want. So it's good to go through a decision process where you really focus on what's the most important to you to achieve in any of these gifts. I look forward to seeing you in future episodes where we're going to talk about more topics about estate planning, working toward that goal always, where we live in the world that I dream of, where every family has got their estate planning in place so that when grief and crisis and transitions strike, the family's got a roadmap and they can spend time together instead of hassling over administrative details. Thanks for joining me. I look forward to seeing you on the next episode of Let's Talk Estate Planning. If this was beneficial to you, hit like and subscribe. And if you're in the state of Georgia and you've got more questions about your particular situation, set up a consultation. Our website is the same as the podcast, letstalkestateplanning.com. And you can set up a consultation with me or the other attorney in my office, Laura Heron, that does a fantastic job. We can help you work through and balance all these considerations to make a good decision on a plan that fits your family. Till next time, take care of yourself, and I'll see you then. Bye.